Good afternoon, everybody. Welcome to another edition of the Construction Litigation webinar series. Today we'll be discussing further issues in coordinating multi-jurisdictional defenses where you have a workers' compensation claim and at the same time, simultaneously, you're defending a general liability claim. Now, just by way of introduction, I am not Tashia Rasul. I am Noah Pollack. I work with Tashia on the construction practice team at LOIS Law Firm, where I am a partner. I've been here about 5 years. And we deal almost exclusively with construction injury claims. And because of that, they almost always include a general liability lawsuit component. So these are issues we've been discussing that come up when you're defending both claims, things you have to be aware of, specific tactics and strategies to use. So today, again, we're going forward with legal issues in coordinating multi-jurisdictional defenses. And today, specifically, we are discussing privileges, disclosure, and estoppel. Just a reminder, it is a live presentation. You are welcome to ask questions on whatever issues arise, whatever you're thinking of. Just send them in, and hopefully I'll be able to get to them at the end of the session. So again, privileges, disclosures, and collateral estoppel. 3 issues. Again, generally we're thinking regarding privileges and disclosures when we're coordinating the workers' compensation claim with the general liability claim. We're talking a lot with the general liability defense counsel. So you have comm counsel and general liability defense counsel talking a lot, exchanging information, exchanging documents. You always have to be cognizant of when you're exchanging information and documents, what might be subject to disclosures on either side, whether on the general liability side or the comm side, and what information is privileged and will remain protected from disclosing to the adversary or opposing counsel. So privileges, we'll go through a few of the central ones. Number 1 on anybody's list when talking about privileges in a legal context is attorney-client privilege. Most of us are familiar with that. It protects basically any information, anything, documents that have to do with providing a legal opinion or assistance in some legal proceeding. If you're retained, we have between the attorney's office and the client, anything that has to do with a legal matter, when their advice is sought or they've already been retained and they're providing legal advice, that will generally be protected absolutely from any disclosures. Something that comes up with attorney-client privileges, usually it's just between, something is protected if it's just between parties of privity. You have the client and you have the attorney. The introduction of outside parties will sometimes lead to a waiver of the privilege. It will destroy the privilege. And so obviously we're thinking about that when you have workers' compensation defense counsel and you have general liability defense counsel talking with often the same client who owns or runs it could be a general contractor, construction developer, or project manager. They run, but they're subject to, they are the defendant in the general liability claim. They're also the one paying on workers' compensation claim. So now you have an additional, you might be thinking you have an additional party when you have defense counsel for the comm claim and defense counsel for general liability claim. So here you have a common interest. You can have a common interest privilege, which falls under the framework of attorney-client privilege. So in this case, if you have different parties, basically lawyers from different firms, one defending the comm, one defending the general liability claim, if they're collaborating with the same client and there's the same shared or common interest, then it will be protected by attorney-client privilege. The second most common privilege that arises in a legal context, there's no difference, is attorney or work product privilege. So any material basically created by the attorney for purposes of litigation, whether it's ongoing litigation or in anticipation of litigation or legal actions or proceedings. It involves research, analysis, conclusions, legal theory, or strategy. That is going to be protected from disclosures. So you're thinking anytime an attorney adds something, it's not just a simple fact or a list, notices. It's when the attorney is taking an extra step and evaluating certain information and then producing something. In that regard, it will be protected by the attorney work product privilege. There are other privileges that would arise in the comm context and general liability claims, sometimes with surveillance materials that are obtained by a workers' compensation carrier. Those are often very much sought after by plaintiff's counsel on the general liability claim. But in the workers' compensation context, that's not disclosed until after the claimant has testified, the plaintiff/claimant has testified. Whereas in a general liability claim, that is disclosed prior to the deposition of the claimant plaintiff. So you'll have general liability of plaintiff's counsel going after it. However, the Workers' Compensation Board is not subject to that disclosure. They don't. It does not have to be turned over. Of course, if fraud is litigated or the surveillance is disclosed already on the comm claim, well, then the claimant/plaintiff already has it, and it's unlikely to be an issue. But again, if the surveillance has not been disclosed yet on the workers' compensation claim, and again, it will not be disclosed until after the claimant has testified. Generally, this comes up in a fraud context where fraud will be raised, and it's disclosed that there is covert surveillance. Despite the disclosure that there is covert surveillance, it will not be directed to be produced by the board or the law judge until after the claimant has testified. And despite the fact that its existence has been disclosed on the workers' compensation claim, general liability counsel does not have it, and they will not have to disclose it. So just a brief overview of documents that arise in workers' compensation context or otherwise, general liability claim. Will they be protected by any of these privileges, whether it's attorney-client privilege, work product privilege, or else have a qualified privilege? So you have FROI's and TROI's reports of injury. When you're talking about reports of injury or accident reports, something to think about is really whether it's an accident report versus an investigation report. Is it done in the regular course of business? Is there just a protocol in place where you take down information if an accident or injury occurs, or is there something more to it? Is it for purposes of expected litigation? The more it's for purposes of expected litigation, or the more something, even an aspect or component of an accident report is for the purposes of anticipated litigation, the more likely it is to be protected. Now, just because these documents are not going to be protected, obviously they're not usually going to be handed over willy-nilly. There'll be a request or a release that's obtained before it's done. Although a lot of the documents in workers' compensation are just produced, submitted to the workers' compensation board file, and they're an e-case, and all the parties to the case, including the claimant and his workers' compensation counsel, have access to that. So you have FROI, the SHROI and OSHA investigation, Social Security earnings, Social Security disability claims. They're not going to be protected, and there's different methods for securing them. Union records, unions are not going to give up the records without a subpoena, so you'll get a subpoena and they'll produce them. In workers' compensation claims, they matter a lot more in OD claims. Contracts and work descriptions, if you want to get an idea of what the claimant was doing, what the employer or subcontractor was contracted for, that's not going to be protected. Now, internal accident investigation will not generally be protected, the accident reports, but again, there are components or maybe enhanced accident reports that involve an investigation, and that will often be protected from disclosure. And then medical records will usually require a HIPAA release. Now, for the workers' compensation carrier, we'll get to it. Usually, HIPAA rules, they're exempted from them, but in practice, medical providers are not just going to be handing over medical records, and you usually obtain an executed HIPAA to get them. I mentioned before there might be investigative components to accident reports, maybe a CIB report, an ISO claim search that might be protected, on-site investigation involving preliminary analysis of potential exposure, liability, what labor laws might be implicated, could be protected. And then we already spoke about surveillance, where in the workers' compensation context, it's not disclosed until after the claimant testifies, and plaintiff's counsel will not be able to get that from workers' compensation carrier. And just in general liability claims, the covert surveillance, they have it is revealed prior, that has to be disclosed and given over prior to the claimant's testimony there. There are social media investigations that are often done now. They become much more important in both the workers' compensation and general liability context for obvious reasons, especially with a lot of younger plaintiff claimants that are active and clearly misrepresenting their injuries, information regarding their lawsuit, what they've been doing. And so those have become important as far as investigation into either the comp or the general liability claim. And again, just like with surveillance in workers' compensation, it's only given over after the claimant has testified, if, for instance, fraud has been raised, whether the claimant's been engaged in work activity or misrepresenting his functional capabilities or his level of disability to doctors, whether IMEs or his own. And we have a social media investigation supporting that. It will only be turned over after the claimant has testified, whereas in the general liability and the lawsuit, it's all given over prior to the claimant's testimony. So like I mentioned in the beginning, often there's a lot of communication in this context between counsel, defense counsel on the general liability claim and workers' compensation defense counsel. And often surveillance, investigation, social media materials, they'll be discussed. It's very important. It's very important that the workers' compensation defense counsel and general liability defense counsel are cognizant of and aware that there's a limit to what should be disclosed in that communication, that really workers' compensation defense counsel should not be explicit, should not be telling defense counsel on the general liability claim that we have this surveillance and here's details about the surveillance and we have this video, and just providing all that information, because that might lead to a disclosure problem if the general liability counsel has this kind of information, specific information regarding video, covert surveillance footage, or what's been turned up in social media investigation. Then all of a sudden there might be a problem with plaintiff's counsel being able to get that general liability counsel might have to disclose it. So you want to make sure that you're not giving over too much information to the general liability defense counsel, that you're aware and they're aware that, you know what, there's going to be a limit, and you may disclose that there's an ongoing investigation or surveillance, but to get into specifics is usually you should not do that, just because you don't want to run into any problems again with disclosure, having to disclose it before you really want to, before you can take full tactical or strategic advantage of it. There are other items that they're rare in the workers' compensation context, forensic experts or environmental studies. Sometimes that comes up with, you know, respiratory claims or mold or lung issues. What was the air quality like? What was their dust exposure? So they have some environmental studies. It's and in the workers' compensation context, there's really no method to force it to be divulged. So clearly, if it's a benefit to defense of the claim, it's probably going to be submitted to the workers' compensation file to support our positions, whether disallowing a claim or minimizing or mitigating exposure. Now, getting back to medical information, generally protected health information is not going to be disclosed without a HIPAA release. There are exceptions. There are exceptions to when a release is actually required, and generally the workers' compensation carrier falls under one of the exemptions if medical information is needed to prosecute or litigate or has anything to do with the workers' compensation claim, defense or otherwise, then it won't fall under the requirement for a HIPAA. I mean, there's other exemptions. Obviously, if there's state law or other laws that require it, or if medical providers want to be paid, it has to do with that. Certainly, it can be released. That has to do with protecting, basically everything having to do with the medical care of plaintiff claimants are protected. Now, workers' compensation records, medical records, the claimant will have to produce the medical records if he wants to pursue a claim. So they'll usually produce to the board file, and anyone who's a party of interest on the claim, employees of the board and the claimant, claimant's counsel, the carrier, the third-party administrator, and workers' compensation defense have access to those medical records. Now, otherwise, you would need a HIPAA release, which is basically the, just regarding the workers' compensation claim file, generally, which goes beyond medical records. There's medical records, but then there's other documents in there. If the claimant executes an OC, what's called an OC 110A, that's going to allow an outside party to have access to the workers' compensation file. Good advice is to have general liability defense. They'll get an executed OC 110A, and that will allow them, once they get it executed, it's signed by the claimant plaintiff, that will allow them access to the entire workers' compensation file, which could be sent over to them. And that includes medical records. They'll usually get an OC 110A. You want to protectively, they'll have an OC 110A and a HIPAA release, and they'll have that executed, and that will allow them, the adjuster on workers' compensation claim could then send over a workers' compensation file to them. Before they have that, though, sometimes, as you're talking about, you're giving a general liability defense counsel an update on the comm claim, synopsis of what's going on medically. And they'll want to look at the medical records, but you don't want to, you shouldn't turn them over until they have the OC 110A, or if they don't have that, the HIPAA release for the specific medical records. Regarding actual discovery in a workers' compensation claim, it's really non-existent. Usually, claimants' attorneys are not requesting certain documents. Almost everything they need is in the board file, and because almost everything is in the board file, and because there's a PH 16.2 requirement, essentially PH 16.2 when issues are litigated, most often this is when a claim is denied, the carrier has to complete a PH 16.2 form, a pre-hearing conference statement, where they have to specify the issues being litigated and what evidence they are relying on, including witnesses or other documents, what are being, and the defenses they're raising that are being relied on controverting the claim, and that they have to produce those. They have to disclose them, and then they're going to have to produce them. And so usually that obviates the need for claimants' attorneys to file discovery requests. There are some times when it comes up, when you're litigating a claim or you have witnesses, and they'll mention accident reports or some kind of document that's not in the board file, and in that case they'll probably make a request, or even the law judge, if it's brought up in litigation and it seems material to the case, the law judge will make that direction for the employer or carrier to submit that. There are other devices that an employer or carrier uses. Obviously, release for medical records, usually they're exempt, but they'll get it. But submission to an IME, they have the right under workers' compensation law to set up an IME and have the claimant go and get examined. Just be careful with those when they're being set up. Communications between defense counsel or carrier employers and the doctors or the IME vendors are there's strict regulations there to make sure that there's no Section 13 violation involved. Keep it simple and straightforward, just what's factual, what you're asking the doctor, and what's in the medical record. There is statutorily, the claimant you can request, and the claimant could be forced to submit a fully completed C3. Law judges will often ignore that, and the vast majority of cases, the claimants have filed a C3. but that is something that a carrier could demand of the claimant, fully executed C3 with all the information provided. And then you have cross-examination of claimant's doctors. You have the right to cross-examine them. Sometimes an issue will be joined. There's going to be contrary medical evidence, but even aside from that, generally the carrier has a right to cross-examine the claimant's treating doctors. The last issue I wanted to discuss was collateral estoppel. Now, anyone following changes in legislation between workers' compensation and general liability, multi-jurisdictional legislation, there was a big change last year that affected collateral estoppel. Now, generally, collateral estoppel means that if you've litigated an issue, you've had a full and fair opportunity to litigate something on the merits, and there was a finding, a formal finding, then, if you want to litigate the identical issue, you'd be estopped. You wouldn't be allowed to do it. You'd be precluded. So in the workers' compensation context, it would arise where you would secure a finding, a formal finding in the workers' compensation claim. That could be as far as whether the claimant was an employee, his work status, disability, whether certain body parts are causally related to the claim, or whether surgeries or medical treatment was causally related to the claim. And you would litigate that. You would depose doctors, take claimant testimony, employer witness testimony. You get a decision from the judge and or the board panel deciding that. Now, you could get a very favorable finding, for instance, that the claimant did not injure a body part in this accident, and that could often be used on the general liability side to stop the claimant or plaintiff from raising that site or damages related to that site on his in his lawsuit. However, and so it would become a very advantageous tool in using the workers' compensation claim and findings secured there to mitigating exposure on the general liability claim. However, that was for the most part gutted, the collateral estoppel, where it's now limited to employer-employee relationship. Now that could help in the general liability context if you get a finding that the claimant was not employed, wasn't properly on site, he didn't work for this subcontractor, this general contractor. So that could certainly be advantageous or beneficial in fighting liability on the lawsuit, but they did gut everything else from collateral estoppel. Now, that doesn't change anything as far as litigating a workers' compensation claim, because again, we're still litigating to secure favorable findings, create jeopardy in claimants' cases, and mitigate exposure. And you're still collaborating using the workers' compensation findings and letting general liability defense know. It doesn't mean there's no value. Just because there's no collateral estoppel and the claimant can't be precluded from raising certain issues, it doesn't mean that the favorable workers' compensation findings are not also beneficial on the workers' compensation, the general liability claim, the action. It's just that general liability counsel will have to leverage it in different ways, not through collateral estoppel, but they'd have to leverage it in different ways to mitigate exposure on their end and get a more favorable settlement. Obviously, if on the workers' compensation context we litigate fraud, and which doesn't have a collateral estoppel component to it, but we litigate fraud, they're using that on the general liability claim. You have a claimant here who's been found to be engaging in fraud and is discredited on certain issues. That's certainly going to be utilized in the general liability claim. It's going to impact exposure there. And similarly, if you're able to secure findings that this surgery is unrelated or this body part was not part of the workers' compensation claim, and you have testimony from multiple parties, including the claimant, employer witnesses, doctors, whether they're IMEs or claimants treating doctors, and if you have that and you've developed the record, that's certainly going to be utilized to help on the general liability claim, even in the absence of having a collateral estoppel. So again, that was a brief overview of privileges, disclosures, and estoppel when you are coordinating multi-jurisdictional defenses. The next edition of the complex claims webinar series construction litigation webinar series is next month, August 7th, when we'll continue discussing coordinating defenses now using milestones. Now, turning to our questions. It does not appear that anybody has any questions. Obviously, if you do, you can always send them over, email to Shia Rasul, myself, anybody at LOIS with your questions or concerns, and we will happily respond expeditiously to allay any concerns you have, provide support, and any answers. So I appreciate you taking the time. I was happy to stand in for Shia and deliver this webinar series. It's enjoyable, and hopefully I will be seeing you in the future for more in the webinar series. So thank you, and definitely enjoy your July 4th holiday tomorrow. Have fun.